Ms. Hassim.
Thank you, Chair. The engagement with my learned friend from the panel has rendered most of my task here redundant, I think. But I'll do my best to cover what I wanted to cover and not dwell on some aspects that have been already fully canvassed with my learned friend. So, Chair, what I propose to do is to address the following in my submissions to the Commission. The first is the legal framework. The second is the reason why granting the application in the particular circumstances of this case is not justified. And in short, what I submit to the Commission is that an in-camera hearing will not offer the protection or remove the threat that Mr. Karim seeks from having this application granted. And the third is to propose an alternative course that may have better protection, perhaps, for Mr. Karim than an in-camera application. So, Chair, let me first say that although my learned friend was a bit dismissive about the attitude of the evidence leaders to this application, we in fact take quite seriously requests for in-camera evidence. We've moved applications before you in the past in circumstances where the facts were more cogent than in this case. And even there, the Commission has not granted our application in the terms that we sought. So even though there were in-camera witnesses, they were partially in-camera, which wasn't the initial request that was sought for those witnesses, and I'll come back to that. But we moved those applications because we take seriously threats to witnesses. So the starting point is the legal framework and Section 4 of the Commissions Act, which governs this proceedings. And what Section 4 makes very clear is that all the evidence and addresses heard by the Commission shall be heard in public. That is the first thing to say about the Commissions Act. That statutory requirement is given effect in the rules of the Commission, which states that hearings of the Commission will be held in public. Rule 4 also expressly recognizes that there may be circumstances in which it is appropriate for hearings to be conducted in camera. The question is whether these are the appropriate circumstances. And according to Rule 9.2 of the rules of this Commission, that determination lies in the discretion of the Chair. My learned friend refers to a series of judgments, including what we call the Masetla judgment, SABC versus NDPP, and others. And the propositions there for when restrictions on openness is appropriate are well established. But they don't do the work for Mr. Karim in this application. The proceedings, and for several reasons, and it is important to say that the proceedings here don't concern the same kind of litigation, inter partes litigation, in which there is a list. It is a public commission of inquiry, and that's relevant when taking into account the weighing up and the balancing exercise that comes once a threat is established. Because the purpose of a commission of inquiry is not only to investigate and to fact find. It serves an important additional purpose, and that is of public accountability in a matter of high public interest. And for that proposition, Commissioners, I'll cite two authorities. The first is the Minister of Police versus the Premier of the Western Cape, and that's to be found at 2014, Volume 1, South African Law Reports, page 1, judgment of the Constitutional Court, and the specific paragraph that establishes this is paragraph 45. It developed the Salfu judgment, and it emphasized that a commission's role is not exhausted by merely advising the executive or the president in this case, but that in addition to doing that, a commission may serve, and in the language of that judgment, a deeper public purpose, especially in times of widespread public disquiet. The second authority is the case of Secretary of the Judicial Commission of Inquiry into Allegations of State Capture versus Zuma. And that's to be found in the South African Law Reports 2021, volume 5, page 1, Constitutional Court judgment, at paragraph 5 in particular, where there, what the court said, again, is that in addition to the advisory and recommendation and policy advising function of a commission, it also serves a purpose of having a public inquiry in respect of matters of high public concern. And the court said the purpose of a public hearing there is to restore public confidence in the institution in which the matter that caused concern arose, which is very similar to what this commission is dealing with. The objective, said the court, is to reveal the truth to the public pertaining to the matter that gives rise to the public concern. So that context in which this commission sits is important in assessing whether appropriate circumstances prevail or that justify the granting of the application that's brought today. Against that backdrop, that legal framework, let me say then that the facts here don't warrant an in-camera application. The applicant brings the application on the basis that he fears for his safety. In fact, he goes further than that. He talks about the safety of more than 1,500 employees. He says, if he testifies in public, that's the risk. He's also referred, apart from the threats that he's received, he refers to the backdrop of 2 witnesses. But we've now covered that extensively this morning, and it was 1 witness that was killed. The second, Mr. Pretorius, was not a witness before this commission. And of course, the investigation is still ongoing as to the circumstances of the assassination of witness D. And so that's been covered again extensively. I'm not going to get into detail about that, but it is important again in weighing up what this application rests, the grounds upon which this application rests. Mr. Karim attaches text messages that he has received from unknown numbers, which appear to be threatening. We don't know the context, further context of those text messages. We don't know what the potential sources are of those text messages. We don't know whether there's anything that is, where there's any hostility or dispute or that's happening within Mr. Karim's workplace that may give rise to this. We don't know what the source of the threats are. But that there are threats on the face of it appear to be clear. They're attached to his application. So we're not dismissive of that, and my submissions to the Commission shouldn't be misunderstood as being a dismissive of the concerns raised by Mr. Karim. But the reality is that the relief that Mr. Karim seeks is not going to assist him. The reality is that Mr. Karim is known to the public. His application in the High Court to delay his appearance before this Commission was widely broadcast. He then appeared before this commission in order to secure a postponement by agreement. Those proceedings were widely broadcast. In those open proceedings, the commission issued a ruling that Mr. Karim is to be present on the 9th and 10th of March for the purposes of leading his evidence, providing his version that he wishes to place before the Commission, and to be questioned in relation to his evidence, particularly on allegations that have been made by other witnesses that have come to the Commission. Now, and let me say this, in the answering affidavit at paragraph 5.1, it sets out a sample of national media coverage in which Mr. Karim's name and pictures are displayed. And that's in relation to the High Court application. In paragraph 5.2 of the answering affidavit, there are examples of widespread coverage that Mr. Karim will be testifying on 9 and 10 March, and those examples include visual images of Mr. Karim's face. So there is no secrecy at all that it will be Mr. Karim who will be testifying in the Commission on 9 and 10 March. What Mr. Karim says in his supplementary affidavit, though, is the following. He says, if my in-camera relief is granted, at best, the makers of these threats will simply not know when, if, or how I give evidence, as the very fact of my doing so will be sealed. And Chair, that is to be found at page 55 of the paginated pleadings bundle, paragraph 9.2 of the supplementary affidavit. Roughly halfway down that paragraph. And I want to emphasize this. What he says is that the makers of the threats will not know when, if, or how I gave evidence, as the very fact of my doing so will be sealed. But that's not correct. First of all, it is known. It is known when he will be testifying. And it's known widely, as we've set out in the answering affidavit. Second, Mr. Karim accepts in his notice of motion that he will testify, and as my learned friend has said earlier this morning, it's accepted that he will testify 9 and 10 March. And so in the notice of motion, the paragraph 3, what paragraph 3 requires is just that the hearing is held in camera on those days. Third, it's not at all a given that that in-camera hearing or that closed session will protect the witness. In fact, it may make him more vulnerable, since those who are threatening him may assume that he has implicated them or given evidence problematic to them when he has not. So secrecy can actually amplify a witness's vulnerability by signaling that the witness is exceptional or hidden, and it may just fuel speculation and targeting rather than quell speculation or threats. My learned friend said just testifying at all is a risk, something to that effect, and I'm not sure that I understood it fully. But again, that doesn't assist, because what we do know is that Mr. Karim is not saying that he will not come to testify. He will come to testify. All he asks is that it should be made in camera, but not disclosing his face or his voice is a practically futile measure, because his voice and his face is so well disclosed. And I must say that Mr. Karim has not raised confidentiality or try to assert confidentiality over his intended evidence as a ground upon which an in-camera hearing is warranted. So we're only dealing with the question of the threats. And I say that he's not raised that because it's not raised on the papers, but also because when one has regard to the statement, and although Mr. Karim repeatedly refused to comply with this commission's ruling on 6 Feb that a written statement be provided by 27 February, he has now filed it. And nothing in that statement appears to place the witness at risk through exposure of third parties in any wrongdoing. The contents of the statement do not disclose any information that was not already disclosed in a public setting before the High Court. So there really will be no practical purpose served by an in-camera hearing. And the threat won't be removed by an in-camera hearing. The threat that, such as it is that that has been put up in the text messages, and I'm assuming for the purposes of my argument that those are credible threats. Now, with regard to the other in-camera applications, there have been 8 witnesses who have applied to give evidence in camera before this commission. All but one of these witnesses were required to testify only partially in camera. That is, in public session, with only their faces concealed. The grounds advanced by those witnesses in their applications were either that testifying in open session would risk compromising ongoing criminal investigations, or serious risks to their physical safety. The reason for concealing the faces of those witnesses was because they were also in witness protection. And their facial identification would have rendered the witness protection measures ineffective and would have materially jeopardized their safety. Their faces were not known to the public, those witnesses, unlike Mr. Karim. Here, his identity and appearance are already in the public domain, as is apparent from the extensive media coverage annexed to the answering affidavit. Masking the witness's face would therefore serve no practical protective purpose. So in those circumstances, even a partial in-camera hearing would be devoid of a rational foundation and cannot be justified on the facts before the commission. So in these circumstances, Chair, in the circumstances of the already public litigation that took place before coming to the commission, and then the public appearance before this commission on the 6th of February, one is hard-pressed to understand how another 2 days of public process will increase the risk to the witness. It is true that there is public attention on the proceedings of this commission. By their nature, all commissions established under the Act are required to be public as a default position. All the witnesses who have testified in open session in this commission have had to deal with this at great personal discomfort. Having regard to what I've said about the public knowledge of the witness's identity and the dates for his evidence, there's no reason to privilege this witness by shielding him from public view. And there's been no argument that can be sustained on the founding affidavit or the supplementary affidavit before the commission that the in-camera hearing would provide protection. As I said, I think it might be counterproductive as far as safety goes. I noted my learned friend, because this point was raised by Commissioner Khumalo about whether it wouldn't be counterproductive. And my learned friend said that might be a glib answer. And I first of all, it's not. It's just a practical reality. And it's a practical reality that Mr. Karim has difficulty overcoming. But to assure the Commission and Mr. Karim and his team that from our perspective as evidence leaders, it's not a glib response. What I submit to the Commission is that there are measures of protection that may be provided to the witness. And I must say that in the supplementary affidavit, the witness says the following, and that's at 9.3.4, paragraph 9.3.4 of the supplementary affidavit. What the witness says is, I quote, "Unlike the Commission and some of its staff that have the benefit of security details paid for by the state from taxpayer funding, I have had to undertake at huge expense and prejudice funding security for my family and me." So the witness has complained that while there's protection provided to the Commission and its staff, he's had to foot the bill for his own protection. I want to clarify and place on record that I've been advised by the Commission's head of security that the Commission has previously offered the witness protection services. I understand that he declined the offer as they already had arrangements in place. The offer, however, remains. And I would go so far as to propose, Chair, that in light of the threats received, the Commission could better protect the witness in other ways, not through an in-camera application, but by renewing its offer of protection services that was made earlier, and to consider the contours of the offer of the protection services, whether it's transit protection or static or both, and to do so on the basis of a threat and risk assessment, which I think, in fact, first of all, a threat and risk assessment with the assistance of the state security or crime intelligence or both would actually be important, because a properly resourced TRA is likely to identify the source and nature of the threat more expeditiously than a report made at the local police station. So it goes to the point, Chair, that you raised at the outset about the credibility of the threat, the source of the threat, what actually lies behind it. And having a well-resourced threat and risk assessment made available to the witness will provide a more meaningful measure of protection for the witness. And I would propose that those measures be considered, and if the threat and risk assessment shows that there's a basis and for providing, whatever range of services are necessary, then that can be considered by the Commission, and if necessary, it may even be in place for the duration of the work of the Commission. And again, I say so on the advice of the head of security for the Commission. But that is a meaningful way to address what the witness has brought to this Commission, the risk that he says he faces and the threats that he's received. It's not the first time that the Commission would be offering services. It's done so for other witnesses who have come, and those witnesses have testified in open. So, in open session. So those are my submissions on the application itself. There are a few other issues I just would like to touch on very quickly. The first is the issue of the bundle that is to be provided to the witness. And I'd like to again clarify that that bundle is not there was a bundle that was provided to the witness some time ago. And what is to be provided today are additional documents that will be used for the purposes of examination of the witness on the 9th and 10th of March. So it's the original bundle plus some additional documents. So the delay is not for the provision of an entire set of documents. It is for the additional documents. The reason it couldn't be provided earlier was because the evidence leaders were awaiting the statement, which only arrived on the 4th of March, the statement that was due on the 27th of February. And the reason for that has got nothing to do with ambushing. The witness seems to be paranoid about the posture of the commission. And there's really no basis to be concerned about that. There's the purpose of the statement is something that is common practice by all commissions, in fact, not just this commission. A witness comes, a witness provides a statement. It's for the benefit of the witness. The witness gets to provide his or her version unfiltered by the evidence leaders. That was why it was important to get the statement. And of course, if the witness were to say he didn't wish not to provide a statement in the end, well, there's nothing much that the commission could do about that, but the cross-examination would continue in the absence then of a version in writing by the witness. So the second thing is what it does is it allows the issues to crystallize, to understand what is actually in dispute and not in dispute, what are the things we need to cover with the witness.
You are left with 5 minutes.
Thank you, Chair. I'll be done in 4. And so it was necessary to receive that so that we could crystallize the issues and know what documents needed to be added to this bundle. It will be provided today. The second is the answering affidavit. The purpose of the answering affidavit was to put up those media reports so that the commission, so that it was properly placed before the commission, so you could have regard to it in determining this and considering the argument of the evidence leaders and where we are coming from when we say practically there is no, it would be futile to have an in-camera hearing. We needed to set that out. That was the purpose of the answering affidavit, not to respond ad seriatim to the applicant's affidavit. So to the extent that there were issues like the 2 witness issues that were not addressed, that was the only reason why it wasn't addressed. Again, we're not in adversarial mode here with the witness. We just wanted to make the evidence of the extensive media coverage available to the commission properly. So I'm going to resist the provocation by Mr. Karim, I won't say by my learned friend, in his affidavits and his remarks about the commission and the commission staff and the evidence leaders. I could say more, but maybe I'll just leave it at what Justice Fisher said in her judgment when she was determining the urgent application that was before her and about what she thought was the unreasonable conduct of the witness in paragraph 19 of her judgment. I won't say anything further on that score. I'll leave it at that, Chair. So that really is our response. I am here addressing the Commission on behalf of the evidence leaders to this in-camera application, Chair.
Thank you, Ms. Hassim. I have just one issue. You emphasize, of course, you've raised a whole lot of other issues, but you've emphasized the question of the High Court application and therefore the fact that Mr. Karim was brought into the public domain, pictures and all, on that occasion. And also that this happened as well when he appeared here. If I understood Mr. Premhid's argument correctly, he's saying none of that changes the situation, which is that after the High Court application, after that appearance, it's only then, thereafter, that there were threats, and that the application relates to the threats, not so much what had happened historically, even if that was recent history, of course. So why the emphasis on the High Court application and also the appearance here?
The emphasis is important, and it's not historical, Chair. And it's not about the High Court application and what it was about or anything like that. What is important is that as a result of the application and the public appearances that the witness has already been involved in, whether High Court or here, his identity is known. So it is, and that can't be changed. It's because of the High Court application and his appearance here that his identity is known. And that's the only point that's the relevance of the High Court proceedings and the 6 February appearance. It's in that context that there were images of his face, that there was video coverage of his appearance before this commission, and therefore he is known. So the relevance of it is, what does in-camera hearing, how does it serve the witness in protecting him? By my learned friend's argument, the only way in which the threat would be removed is if he did not testify at all before the commission. That's the only way the threat would be removed. But as it stands now, he is publicly known. His face is known. It's known that he's going to be here on Monday and Tuesday. To just pull a curtain over it and have the hearing
not necessarily here, because at this stage you do not know what my order or direction will be.
Fair enough. Fair enough. I'm saying if it were to be in open session, it would be, the dates are known. And so the identity and the revelation of the identity of the witness around that time, the High Court application and appearing here, has made the in-camera application redundant. That's really the only point of referring to those.
Thank you, Ms. Hassim.
Isn't a further factor that it's known that he's going to testify already from the date that he filed his application in High Court, and when he appeared here and a date was given. So the world, whoever's making those threats, knows that he's been ordered to come and testify on Monday and Tuesday, the 9th and the 10th. And the application as it stands now, it doesn't ask that he does not testify on the 9th and the 10th. It doesn't. So the assumption has to be, or the prevailing position as matters stand, is that he will testify on the 9th and the 10th. So whoever he's afraid of knows that he is testifying. He's not being excused. You want to say something about that?
Commissioner Baloyi, that really is it. It's a practical point, really. And it's why I referred to that paragraph 9.2 of the supplementary affidavit, because what the witness says is that the makers of the threats will not know when, if, or how I give evidence. That's just not true. The makers of the threats will know when, if, and how Mr. Karim will be giving evidence.
Thank you. We'll hear what Mr. Premit says about that.
Just maybe 1.5 points from me. For the purposes of this application, we should accept that the threats are credible, because there's no suggestion that they are not. You agree?
All my submissions are on the basis of accepting that the threats are credible.
So we must start from the premise that there are threats. Now, accepting that as a fact, do you think an in-camera hearing of the evidence would eliminate those threats? I mean, based on what we have heard, I'm not asking for your opinion, but based on the evidence that is before us.
Well, okay, so let me explain what I say when I say the threats are credible. What I mean is, I think it would indeed be glib to not take threats seriously. However, there is an issue of insufficiency of the evidence. Some of it was already, and I didn't go there because it was covered already by Commissioner Baloyi, about whether the messages that are attached to the affidavits actually show that it's a threat that is emanating from this commission, or whether it has to do with something else. And I've heard my learned friend say, well, you've got to see it in the context of when the threats were made. I accept that, but it's not a full answer. the evidence is insufficient. So I just want to be understood properly when I say it's credible. I just mean that I think it would, from my perspective, I take it seriously, but it's not the application, the sufficiency of the evidence for the purpose of the application doesn't satisfy, I think, what this commission needs to determine. So
I understood Mr. Premier to be saying, because we don't know where it's coming from, we must err on the side of caution. Just because we're not certain that it's related to the commission does not mean it is not. So sorry, Commissioner Kamala. So the first is the issue of the sufficiency of the evidence, but it's also not knowing, it's precisely not knowing that, which is why at the tail end of my submissions, I propose that, well, let's get to the bottom of it. Where is the threat coming from? And how can the commission assist the witness in that regard? And that would be, as I said, more meaningful protection than an in-camera application, because everybody will know that the person behind the curtain is the Wizard of Oz.
Thank you, Ms. Hassim. Mr. Premier?
Yes, thank you, Chair.
Just a minute.
Oh, apologies.
Only 10 minutes, Mr. Premier.
Is that protected time? Or in toto?
All told.
I have 14 points to make very briefly in reply.
Sure.
Was that 14?
14, yes.
Sure.
I'll do it in 10 minutes, but I will...
All right.
I have 14 points to...
10 protected.
Okay, I take that. Thank you, Chair. Let's start at the end. My learned friend says that Mr. Karim will come here on the 9th and 10th if the in-camera application is granted, and all that will be done is his voice is going to be blurred, or they're going to distort his voice so that he's not known. My learned friend is interrupting. I apologize. I don't know if this is going to cut into my protected time. That's how I understood the submission. But Ms. Hassim, yes?
Chair, can I just correct it? Because you may go down a path then, Mr. Premier, that is not warranted. Not a distorted voice or that kind of thing. It would be in camera. That is what's requested. It would be a closed, sealed session.
Yes, but the specifics of that request are set out at pages 11 and 12 of the founding affidavit, where at paragraph 23, the witness says, it appears that the individuals are tracking my movements and will be monitoring whether I attend at the Commission's current premises. In this regard, I request that my evidence be led in camera and virtually, alternatively, at an undisclosed location. And then at paragraph 25, it goes on to talk about the purpose of moving the application in the context of being monitored. So actually, the presentation that the in-camera relief is simply to come here in secret on the 9th and the 10th, properly construed is not that at all. It's about getting appropriate directions from the Commission for alternative accommodations that will give the protection of an in-camera session in the way that my learned friend has said, if we come here on the 9th and the 10th, it won't be. So I agree with my learned friend's submission in that regard. May I just also say regarding this sudden offer that is being made about security and whatever else might be the case. I heard my learned friend to say that the head of security made a direct offer to this witness, i.e. my client, and I am instructed by my instructing attorney that no such offer has ever been made. And therefore, the further submission that that offer was rejected also falls to the wayside, because you can't reject something that you haven't actually received. But let's just assume it was made. Why did we have to bring an application and have to come to fight a full in-camera hearing when that is a practical offer that the Commission could have made earlier? And so my learned friend says, rather conveniently, we're not here in adversarial proceedings, we're here in an inquisitorial context. But she then tenders at the last moment, literally in her answer in the in-camera application, something that could have remedied my client's prejudice, which has never been tendered before and has never meaningfully been engaged. Why is it that we are subject to this kind of treatment in this particular context? Regarding the other points that I need to make, that's 2 of the 14, by the way. Yes, the bundle is coming. The bundle was meant to be served 2 business days after the witness statement was filed. That was filed on the 4th of March at 9 o'clock. I'm instructed that it's almost 20 to 3, 2 business days later, and we still haven't received the bundle. So I must raise that in the context of the ongoing prejudice that my client faces at the hands of the commission's, and I say this with in a slightly guarded manner, heavy-handedness in how they have treated my client. So regarding also the throwaway remark that my client is seeking to be privileged as a witness is utterly unacceptable with all due respect. He's not asking for any privilege. He's asking for a procedural determination by the Commission of the rights that the Commission's own rules give him. And to present it as being a privilege actually suggests that the Commission characterizes my client's application as seeking something to which he is not entitled. And that's not correct, because what he is asking from the Commission is something that the Commission's own rules entitle him to. Regarding some of the authorities that my learned friend cited, may I just make 3 brief points about that? The first one is that I sent my learned friend my list of authorities earlier. I asked her to do the same. She didn't, but it's fine. Point number 2 is that those authorities, with all due respect, are irrelevant to the issue at hand. Those speak about the important public function that a commission is supposed to play. That's trite. It's common cause between the parties. The question we have to ask ourselves is whether or not that as the default principle and the baseline can be derogated from, having regard to the 6 authorities that I cited, which said that openness is not by default, it's not absolute, and that it can be derogated from in circumstances where, for example, there's a serious threat to security. And whilst I'm just complaining about this, let me also say that this was not the case put up in the answering affidavit. So this is the first time that we're hearing about that. But be that as it may, we're not in a strict court proceeding where affidavits need to be dealt with in that way, I suppose. Let me just also say that we have things that are thrown at us that we learn about for the first time regarding, apparently it was 12 witnesses or 8 other witnesses and all these other kinds of things and what they did or didn't do or whatever the case might be. This is knowledge that is squarely within the commission's, and when I say the commission, I mean the evidence leaders, the staff and the attorneys within their knowledge. And instead of then drawing us into a proceeding of this kind, this information could have been tendered to us well in advance and we could have had a reasonable engagement with each other. The only reason that we are here at the moment from the Commission is precisely because we are treated in the manner in which we are treated. Chair, I see I have 4 more minutes, which I will try to use to the best of my ability. And also, with all due respect, the fact that we are here now in the circumstances in which we are here now demonstrates not only the abusiveness that my client has been subjected to with respect, it's also that this whole exercise by the time we're here has been rendered futile because of the manner in which the proceeding has unfolded in front of the Commission. So even if the Commission was still minded to give my client some form of meaningful relief, regrettably, most of the relief that he could otherwise, or most of the relief that he could otherwise have been entitled to is now lost because of the way in which this in-camera application has unfolded in front of the Commission. And the point that needs to be repeated is that it's not the public nature of my client's exposure to public knowledge that gives rise to the in-camera. It's the existence, the factual existence of the threats and the timing of those threats and the way that they have arisen. And so in those circumstances, we would say that the appropriate thing to do here is to grant my client in-camera relief. If it has to change Schedule A, who's included and who's not included, that is something that the Commission will determine and we will respect. And the Commission will also apply its mind to what is said at pages 11 and 12, paragraphs 23 onwards of the founding affidavit regarding the modality of that evidence. And may I just conclude then on this point in 2 minutes to spare, is that one of the letters that were placed in front of the Commission was an explicit request for confirmation that all of the correspondence in this matter, as well as all of the pleadings, had been promptly placed in front of the commissioners because of the fact that we required a ruling before the 25th. And that was never responded to despite the request being made. And the reason I raise that is because that concretizes the prejudice that my client faces in circumstances where he engages the commission evidence leaders and staff on one hand, and things don't necessarily go through to the commissioners in the way that we don't know whether it does or it doesn't, and then he's caught with the consequences arising from the way in which the Commission's evidence leaders and staff choose to handle requests made of them, including requests where matters are asked to be raised with the Commissioners on an expedited and time-sensitive timeline. And so, quite frankly, having regard to all of that, and the fact that factually at the end of the day, everyone accepts that these are credible threats, and that they do exist as a matter of fact and as a matter of the record, we would pray for the relief sought in the notice of motion, subject to those amendments that I have suggested are possible amendments like the one I discussed with Commissioner Khumalo. May I please take an instruction? Thank you, Chair.
Mr. Premier, I'm concerned that with the posture, and I'm concerned because I am not aware of the facts. I don't see the facts, maybe let me say it. I don't see the facts on which you base the kind of contentions or statements that you're making. You have this consistent complaint that your client is being treated exceptionally badly, is being victimized, high-handedness. In fact, if one went through your client's affidavit, there's really quite a number of concerning statements. You know, in your supplementary affidavit 932, you speak about brinksmanship. In 934, you speak about a fishing expedition that the commission wanted his statement as part of a fishing expedition. But over and above that, there's this hyped up criticism of how he's being dealt with. You haven't placed to us, before us, facts that support those kind of strong statements. And I think there is a responsibility, especially for, at least as far as I'm concerned, there is a responsibility for legal practitioners to advise their clients when a statement is required by the commission, because our rules say so, because the chairperson directs statements must be filed. I think I think you'll agree with me that legal representatives have a responsibility to say to the client, you can't call it a fishing expedition. Statements must be filed, right? We do have that responsibility.
Absolutely.
And here there's this gratuitous statements about how badly he's been treated, including on something like this. It's not backed up by anything in the conduct of the commission. You know, the chair earlier dealt with you, spoke to you about some of the language and gratuitous statements that are made, but in fact, there's quite a number of them here. I'm concerned that your client is on a path that seeks to publicly create the impression that this commission has got something against him. And there's no basis, absolutely no basis. And I want you to deal with just one example. Your attorneys wrote a letter requiring a response and rulings by a certain date. They had unilaterally fixed dates. And there was no justification in that letter why the commission must make rulings by a certain date. We're just told Just give us rulings by this date. You're complaining about the response that you got. We didn't give you the ruling on the date that your attorney demanded it, because that's what it was. You're complaining about that as if it was there for your client to take. It was for the attorney to write, and the commission must give a ruling on the 25th. And if we don't give a ruling on the date that has been dictated by your attorney, we are treating your client unfairly. Something that I can answer directly to without having to file an affidavit is the demand to place it before the commission, that letter that said, please place this before the commission. Commissioners, in fact, it happened. And your attorney got a response saying, we acknowledge receipt. It will be placed before the commissioners and they will deal with it in due course. There is that kind of response that was sent. And I say that because I know it happened. But that's not even the nub or the essence of what I'm speaking to. I'm speaking to this tone, this consistent tone since morning, that your client is being treated unfairly. You haven't suggested, or he hasn't suggested, why we would do that to him. He hasn't. He's just been happy to say, I'm being treated unfairly. There's this high-handedness. There isn't. He appeared here. He was told to file a statement by a certain date. He did not file by that date. Instead, he wrote a letter to say, well, give me directives. He doesn't file on that day. He's told you have to file. So I don't see any facts here. And it's important what you're saying because it carries. And it carries. This is a very public process. And it carries, and I think it should be called out. If your client has got facts, he must list them and let the reasonable person judge on that. But as matters stand, there's nothing of sorts. It's just gratuitous statements. What fishing expedition, what interest would the commission have, and why him when all other witnesses, we've had many witnesses appearing. This is the first time that we have a witness who says, well, you want my statement as part of your fishing expedition. We've had in camera people applying. They have happily filed statements that set out why they should be heard in camera. This is the first time that we get a complaint that this is a fishing expedition. I'm really, and you can comment as you wish, but I'm really expressing a displeasure with the conduct of Mr. Karim, but also because it's not substantiated by anything that he has put before us. You may comment if you want to.
Thank you, Chair. Commissioner Baloyi, I'm now going to read from the correspondence because I don't know if the correspondence bundle has been placed in front of you in the way that we asked. But on the day that the application was launched on the 18th of February, this is what the attorneys say on the record with prejudice.
But the postponement. What application?
No. This is on the 18th of February when this application for in-camera is launched, Commissioner Baloyi. The attorneys say, as you would appreciate, due to the sensitivity and urgency of the matter, bearing in mind the date for the submission of our client's statement, in respect of his evidence, we request the aforementioned application be urgently considered by the chairperson and such ruling is issued by or before the 25th. In that same letter, it says, in our respectful view, it can be decided without oral submissions on the basis of the application. Should the chairperson require submissions, we are amenable to do so at a time that is mutually suitable, taking into consideration the need for a ruling by or before the 25th. And you'll remember that is coupled with an application that seeks condonation for non-compliance, both in terms of the rules as it applies to the timing of the in-camera, but also explicitly says, I need a direction in respect of the filing of the statement so I know what my position is come the filing deadline. On that day, Commissioner Baloyi, the response from Mr. Popkas says, it's not that it's being placed in front of the commissioners. It says instead, we confirm that same will be relayed to the secretary and evidence leader shortly, and we will revert with formal instructions in due course. And then 5 days lapse. And on the 23rd of February, a letter is written, and it's a 2-page letter, and I'm not going to read all of it. But what the attorneys say is, kindly advise whether the application has been served and further when we can expect a response. In the event the application has not been served, what are the reasons? We remind you of the urgency in response to our client's application premised on the order of the Commission. And we refer you to what we set out in paragraph 7, which is what I read out about that 25th deadline. We reiterate that request. And then on that same day, we get a response that says, we acknowledge receipt of your correspondence and confirm that same will be directed to the relevant functionaries for consideration.
My point, Mr. Pramit, is how does it all justify this is victimization? That's my point. My point is, remember where I started. I said there's this consistent theme that Mr. Karim is being treated exceptionally badly, victimized. You've said, I think we've been adversarial. The Commission has been adversarial towards him. All the strongest words that he could think of are in his affidavit about how badly he's being treated. But not just badly, but like he's being targeted, he's being victimized. And that's my issue, that sequence of correspondence happened as it did, right? How does it translate? When do we get to the point where you say, this is my client being particularly victimized? That's why I referred, and for me, that's an easy example about the statement that, all witnesses have to submit statements. You have a witness say, oh, this is a fishing expedition. I've asked to be heard in camera. Now you want my statement. And you want my statement because you want a peek, to have a peek into what I'm going to see. What I'm saying is, surely, what interest do we have, right? Why would we want to fish when we're going to have a witness here? He will come and testify. We'll ask him all the questions we want to ask. Yes, so there's not, basically the point I'm making is there is no basis for this strenuous complaint that is being put out there that this particular witness and just him, because we've never had this complaint, just him, why would we treat him badly? Why? The one witness who came here applied for a postponement. On the basis I don't have documents, I have people who are, my lawyers are not going to be available, actually got a very generous postponement, right? To go get ready, have your lawyers available. That you don't, as you say, context. That context you don't speak to, but you nitpicking on matters of engagement with the evidence leaders, with the attorneys, and you elevate it, or I accept you're a creature of instructions, and so it's not your personal positions that you're putting forward. But why he would be targeted by the Commission? What's there to gain for the Commission? And I think those are critical questions that should be asked before he puts stuff like this on, in the public domain.
Thank you, Chair. Through you, Chair. When I was engaging with the Chair in the morning about the other instances of prejudice claimed by my client, that was a cumulative assessment of not only this chain of correspondence, but other instances where the Commission has conducted itself in a way that reasonably leads my client to believe that he is being treated in the way that he is. I understand what Commissioner Baloyi is saying to me, that in Commissioner Baloyi's view, there is no basis upon which to make such a statement, and that the stridency of the statements is a concern for Commissioner Baloyi, but more broadly than that, that it's a concern insofar as the integrity of this commission as it may be viewed in the public. And Commissioner Baloyi, I would entirely agree with you. The consistent complaint from my client has been that the Commission has a set of rules. There are instances where not the commissioners sitting on bank in front of me, but through the evidence leaders or the attorneys or the staff or whatever the case might be, there are instances where non-compliance with those rules are identified. That may or may not turn out on legal interpretation and whether that view is right or wrong. But what it implicates is that my client is the subject of coercive force by this commission. And unless my client is represented by a legal...
Coercive force having manifested where? Just tell us
It's the threat of the coercive force. I'm not saying that there has been coercive force. I'm saying at each one of these instances that you've put to me, where the stridency emerges from Mr. Karim and his legal team, I'm saying that in each one of those instances, the threat of coercive force hangs over my client, that if he is found to be in breach of the commission's rules, or what, even where to be found in breach of those commission's rules is subject to a legal debate where his legal representatives say, actually, the commission is not following its rules in the first place. So why
No, can we just clarify this? You say he's the subject of the threat. I understand you to be saying the threat of coercive force, but that's true for everyone who appears before us. If they haven't complied with a directive in the way that your client did not, right? There was an order by the chair. You must file your statement by a certain date.
Yes.
Now, there's nothing exceptional about your client on that kind of order. And when he doesn't comply with it, to say that you will be subjected to the powers that we have, that you will be held in contempt of the commission because you haven't complied with a ruling, a lawful ruling of the chairperson. There's absolutely nothing wrong with that, and there's nothing to complain about.
No,
he may justify himself and say, I didn't comply because I was waiting. I was hoping you will give me a directive just like I asked for, right? He could give that as an excuse for non-compliance, but as a matter of law before us here, right? If you don't comply with the directive of the chairperson, you are in contempt. Whether we act or we postpone acting is a different matter. So it's an inaccurate reflection of the position to say that, well, he's being unfairly subjected to coercive force because he has been told he's in contempt and therefore he will be, measures will be taken against him. Sorry, I don't understand that complaint.
No, that's not the complaint, because we're not complaining about the trite proposition that the commission has the power to use coercive force in instances of non-compliance. What we're overlooking, with all due respect, Commissioner Baloyi, in the way in which you've put that limited factual scenario to me, is that there was an application as an intervening fact to say, please define.
That application did not displace, there was never a suggestion from the commission, Mr. Premier, that because there's a pending application, you don't have to file. And the commission doesn't get dictated upon by a witness who decides, I do have a ruling. I have a clear ruling to file by a certain date, but you know what? I'm not going to file. I'm writing a letter to say, give me directives. I have a pending application, therefore I'm not filing. That's not binding on the commission. He was given a clear directive and he was in contempt of the directive. Simple. But with
all due respect, Commissioner Baloyi, the ruling was asked for before the statement was due. And that's why we can't simply ignore the factual intervention of the application. If the application was dismissed by the 25th, then he would have had to file on the 27th. We can't deal with the hypothetical of non-compliance without factoring in the fact that the witness himself came to the commission and said, I know what my obligation is, but here's a related issue I need you to decide upon before my statement is due to help me clarify what my obligations are.
The problem isn't that before, that he determined, he determined for us, before I file my statement, give me a directive. And then when he doesn't get that directive, he chooses not to file his statement. That is where the problem is. And I'm not sure why we're having this argument when in fact the reality, the factual reality is there was a directive. It had a fixed date for compliance. He did not comply. He has an explanation. And that's my complaint, if it's a complaint at all, for lack of a better word, is that he superimposed before the statement was due, between the date of the directive and before the statement was due, He then superimposes something. He says, give me a directive. And then he goes and make a decision, I'm not filing because they didn't give me the directive on that day. And the simple point I'm making to you, and that I didn't expect would be such an issue of contention, is that he wasn't entitled to do that. He did it anyway, but he wasn't entitled to sit back because he doesn't have the directive that he's asked for and that he has put us on terms, by the way. He puts us on terms to give him a directive by a certain date. When we don't give him that directive by that date, the simple point I'm making is he wasn't entitled not to file his statement in accordance with the directive. And when he is told that you did wrong by not filing by that date, it's not open to him to say, I'm being victimized. That's the simple point I'm making. It's not open to him to say that.
Unless perhaps I'm wrong on some legal basis, it seems to me like somebody that were to act as if there is an interdict in place when in fact there is none.
Chair, may I say something on this?
Not in the middle of Mr. Premier's
Oh, sorry.
argument.
I thought you...
No, the
Yes,
commissioners
Mr.
are very
Premier.
active on a Friday afternoon.
maybe-
I'm not done. I
Please,
hear,
please
I
respond
hear,
to Commissioner
I hear
Baloyi's
exactly
question.
what Commissioner Baloyi says. I think where Commissioner Baloyi and I depart company is let's use a high court type of scenario. A high court gives an order that is going to, compliance with which is going to have to occur by the 27th of February. Let's use our exact dates. And before the 27th of February, an application is placed before the High Court that says, I need you to determine an issue, whether rightfully or wrongfully, whether imposed unilaterally, whether placed on terms. The fact of the matter is an application is launched before the compliance date to say in the High Court, determine the terms of my compliance, because I'm concerned if I comply in the way I'm currently expected to comply, that's going to cause me some or other prejudice or harm or whatever the case might be. I think where Commissioner Baloyi and I part ways is that, on my understanding, given that it wasn't just a letter, it was also an application for formal relief under the Commission's rules with a prayer for condonation with the associated timeline, that demonstrates an absence of willfulness for the purposes of the so-called non-compliance, because there's a legal issue that is sought to be determined before that compliance and or non-compliance can arise. But I've heard what Commissioner Baloyi has said, and Commissioner Baloyi's view is that is not correct, and that notwithstanding your application, and please correct me if I'm wrong, you actually should have complied, and that your failure to comply is what has caused the concern for the Commission. I hear that, and I accept the remarks made by Commissioner Baloyi. Obviously, I do, but I would say that the fullness of the answer that I can give is that he didn't sit back and simply not comply. He came to the very body that will determine the consequences of his compliance or non-compliance on the 27th and said, please give me a directive on this particular issue that is materially connected to that compliance, which I know I have to comply with. If that was the wrong approach, that is the wrong approach, and we have to take the proverbial beating that we receive for that. But as long as it is on record that my client didn't just simply write a letter or sit back or sat on his hands, but that he engaged a formal procedural process to help him clarify the terms of his compliance in respect of that particular date, then that's as far as I can take it. But I take that, Commissioner Baloyi, and may I also say on the record that this is now the third instance that the Commission has raised languaging and stridency in the conduct of the legal team, in the conduct of Mr. Karim's legal team. As Mr. Karim's leading counsel, I will take responsibility for that. And I again apologize to the Commission for those terms. But I hope the Commission will understand that the obligation on us, on as Mr. Karim's legal representatives, in circumstances where he could be the subject of coercive force, is to represent him to the best of our ability with no regard to personal consequence, fear, or favor. And so I take the admonition in the way that it is delivered, and just to assure the Commission that that was never meant as a sign of disrespect or willful non-compliance, but it was in what we see as the legitimate pursuit of our responsibilities to our client as his legal representatives. Thank you, Chair. Thank you, Commissioner Baloyi.
I accept that, Mr. Premier.
Mr. Premier, this is directed to your client and other witnesses that are still to come, and this is very important because officers of this commission don't get to speak for themselves, and allegations are made in the papers that affect the officers of this commission. I just want to place it on record that the rules of this commission require that they take the oath of secrecy to preserve confidentiality of any document that comes to this commission. And Regulation 12 says if they breach some of those regulations, it is an offense. So all of them take that obligation very seriously. And we as commissioners, we administer that oath and we make it clear to them that, these are your obligations. Everything that comes here is to be treated as confidential. I just needed you to know that, and any other witness that comes after your client, they know that. So that allegations should not be made that if officers of this commission come across statements or documents, they won't treat them with confidentiality. I think it's very important that that is made clear because that was the fear as I understood it. And it is put on affidavit. They don't get to speak for themselves. But we know the regulations. As I said, some of these documents are on the website. So can we just understand that so that going forward, you know that that is the position. It is not directed just to your client, but anybody that comes after your client.
Of which I assume there's going to be many. But
I hope they don't repeat what was said this morning.
Commissioner Khumalo, may I say I accept that. And indeed, had the confirmatory statement of what you just put to me, which we received in the directive on the 3rd of March in paragraph 7, be said on the 18th of February, then that might have changed our position being in front of you. But I've heard what you've said, and I'm sure all the television cameras have flighted that as well. Thank you, Commissioner.
If they repeat it, I'm going to blame you.
Wouldn't be the first time, Commissioner Khumalo.
You wanted to say, or should I quickly raise my issues and then you come thereafter? You want to come in now?
Chair, it is related to the issue of...
I just hope it won't result in an unending ping pong.
No, Chair, I'm sure you will ensure that it doesn't.
Yes.
It really is to say two things. First is that the effect of bringing the application on the 18th of February was not to suspend the ruling of the 27th of Feb. And so I hear my learned friend saying...
I think that was the first, or after my preliminary point, I think that was one of the very first issues I raised. I think Commissioner Baloyi as well has touched on it. I think the point has been made in that regard.
I won't say anything further on it, except it was important from our perspective as the evidence leaders, because there are allegations that are being made about the evidence leaders in this. And so it doesn't suspend the ruling. It was important from the point of view of the evidence leaders in the way in which they handled that application going forward. But the second thing was that my learned friend said that the statement was materially connected to the application. And that was not at all apparent. And until this moment, it's still not apparent to me how it is materially connected to the application. If Mr. Karim had said, my statement will contain information that cannot be disclosed, and that it's part of my application for the in-camera hearing. Part of why I need this is because I'm going to say something that has to be kept confidential. That I understand. But that's not the the ground that was advanced in the application. And what is in the statement is not anything that has not already been said in public in the High Court by the witness.
Thank you, Ms. Hassim. A quick response to the second point only, please, Mr. Premhead, if you have it.
All I'll say is that I don't know what more my client can be expected to do in the circumstances where he comes to the commission, places the application and the correspondence where the exact justification sought by my learned friend is placed. And that's not to do what my learned friend has, I think, suggested, which is that it's about the content of the statement. It's about the status of disclosure it's the status of the hearing prior to the disclosure of the statement, not the content of the statement itself. So that's the consistent line we've taken in these proceedings.
Thank you, Mr. Premhead. I have two very brief points to raise. There's the issue of the offer of protection. There's a dispute as to whether the offer was made previously. I will leave that and proceed to what the attitude is now, because Ms. Hassim has said the offer is being extended even as we speak. Is there a response? If not, will a response be given to the evidence leaders as soon as possible in this regard?
Chair, may I say that we have to take an instruction and we'll give a response. But I must just say this.
Yes.
My client is scheduled to come before this commission within 48 hours. My learned friend was talking about things like threats assessments and all these other kinds of investigations that need to happen. So I mean, practically speaking, even if he wants to accept that, I don't know to what extent all of the necessary processes are completed within the 48 hours that he has available. But we'll take an instruction and we'll come back to you on that. Thank you, Chair.
Thank you. Then there's also the issue of the supplementary bundle. This morning I understood you to accept that that's due today and that you will accept it when it's finished today. But when you were arguing this afternoon, I understood you to be saying it was due at a specific time this morning and that by now it's late already. I just want to understand what exactly you are saying in this regard. What's the point of substance being made in this regard? Are you saying it's late and therefore your client will be prejudiced if your client gets it later than whatever the morning time was?
Yes. And the reason for that is that we were under a time pressure to file by a particular time that was specified in the directive handed down as 9 o'clock. 2 days later, business days later, 9 o'clock, the supplementary bundle has not been given. We are now here on the Friday afternoon at 3:15. I'm instructed it's still not being given.
What were the exact terms of for the filing of that?
You'll remember that comes from the original order you
Yes,
gave
but
in the context of
what were the exact terms?
within 48 hours of the receipt of the statement. And so now I'm saying 48 hours has actually lapsed. And I'm not just complaining that 48 hours has lapsed. What that has an impact on is from Friday, 9 o'clock, until my client has to appear in front of you on Monday at 9 o'clock or whatever the actual time is, the absence of the bundle since this morning is now eating into our...
What time was it this morning?
9.
9.
That we had to deliver the statement yet. We had
No, the bundle, the supplementary
We would have
bundle.
anticipated it 2 days later, meaning 9 o'clock today in the
Today,
morning.
9 today.
Yeah.
And at 9:30 you were here.
Yeah, and it hasn't come.
And would you have used it meaningfully, or is this a technical point?
No, we
Mr.
would have.
Mr.
As you might notice, one of my team is not here today because he's off sick. But he would have been the one to take up. He was off sick and not present because he has a contagious illness, which means he should be isolating. But he would have been in the position to already start looking at that bundle, engaging our client, and so on. And so that's just the reality of where we are placed.
But Mr. Premhead, this point about the exact hour was not made this morning. This morning, you seem to accept that this bundle is to be given to us today. And it was already past 9 o'clock, and it did not suggest that you are late because you did not give this to me at 9 o'clock. It seems to me that this is an about 10, and I'm not taking kindly to that at all.
No, I accept what you say to me, Chair, and I'll say that it's not an about turn, because when we were given
It is. If after 9:30, when argument commenced, if after 9:30 you said the supplementary bundle is due today, and you said it in a context that was receptive to the idea of that being given to you later than the start time of the argument, all of a sudden now you are insisting on 9, and you are already past 9 when you made this point. That is why I'm saying this is an about 10. If you want to, we can actually listen exactly to what you said. And I think I'm correct on this.
No, I don't think that's necessary. And I hear what you say to me, Chair, but all I'll say is that even if 9 o'clock wasn't the fixed time, or alternatively, my failure to mention the 9 o'clock issue when I addressed you earlier now causes the effect that it didn't have to be given at 9 o'clock. The point that I would make simply is that it's now Friday afternoon, or almost 4 o'clock.
Do you remember as you were arguing, I think I even asked Ms. Hassim, will this supplementary bundle be served today? And you said yes. And Mr. Premier, you never said, but that will be late already. You never said so.
Chair, may I?
Yes. Yes.
Because what is happening here is important. It's again the applicant creating rules and demands.
No, please respond when Mr. Premhead is done. Let's just continue with the debate with Mr. Premhead.
It's on the same point, Chair, but okay.
No, so that you don't, it doesn't become a dialogue between you.
I never know when Mr. Premhead's done or not.
Yeah, no, you're still arguing. I hope you follow what I'm saying, Mr. Premhead. After 9:30, during your argument, you, in a manner that is receptive to the idea, accept that the bundle is going to be served. You do not appear to be opposing that on the basis that it was supposed to have been served at 9 o'clock, and therefore it's late already. You did none of that. If anything, as I've said, I think 2 times already, you were receptive to the idea that the supplementary bundle was going to be served after 9 a.m. in the morning. It's on that basis that I say I see this as nothing but an about 10. It's on that basis that I say so. And I added that I do not take kindly to it.
Chairperson, I'm instructed that the bundle has now been emailed to us whilst we've been having this engagement. So my prejudice is cured.
Thank you very much. Thank you very much. Those are the only 2 issues I wish to raise. I wished to raise with you, Mr. Prem. I don't want it to get to the ping pong that I said I do not want it to become.
No.
This issue has been resolved now, Ms. Hassim.
Chair, can I just put one point of clarity? There was never any agreement that would be filed by 9 o'clock this morning.
No. I understand that perfectly, but I understand the point to arise from a mathematical calculation of 48 hours, not that there was any agreement. But I'm saying what I said despite the mathematical calculation because I just find it very strange. Yeah.
I appreciate that, Chair. My point is not about yours. It was about...
No. Even the
48 hours was never...
I guess I'm addressing
Yes.
Mr. Karim through you. Yes.
It's merely to say that the 48 hours was never an agreement.
No.
The 48 hours comes from your ruling on the 6th of February
Yes,
relating to a different set of documents.
All right. No, thank you.
Thank you, Chair.
Thank you, Council. Thank you all, to all of you. I will make my ruling on this at 9:30 on Monday. And I hope that it will be a written ruling which will cover both the reasons for this morning's ruling and also then the ruling on the aspect that's been argued now, plus the reasons for it. We earlier touched on the possibility of the filing of a supplementary affidavit on the issues that I engaged Mr. Prem Head on. I do not even trust my memory to be able to articulate those. I trust your memory more than mine, Mr. Prem Head, on that.
To interrupt you whilst you are talking, but my learned friend indicated she also doesn't remember. I remember that this possible supplementary statement is to deal with issues such as who could potentially be the source of those
that
threats.
was the thrust of it.
Yes,
That was the main.
the circumstances and the reasonable
yes.
version of the
That
crime.
was the thrust of it.
Yes.
Thank you. I direct that a supplementary affidavit, if any, underline if any, must be filed by midday tomorrow, and a response to it, if any, by 7 p.m. tomorrow. That's the direction, but I may just add that by making the direction, we're not necessarily saying that anything will turn on that. But when you write your reasons, you never know where the pen might lead you. So I want to avoid a situation where we just might say, oh gosh, if we had directed that there be such a supplementary affidavit. So it's on that basis that I'm giving that direction. Let us adjourn and resume at 9:30 on Monday. And we will resume here. Perhaps let's see counsel outside regarding the practicalities and so on. Let's adjourn.